Swayam Prabha. Digital India. Educated India.
Dear students, yesterday we were discussing about tying arrangements and intellectual property, and today we are going to discuss about the price fixing and antitrust law. How the price fixing of intellectual property on products and how it is interacting with the competition law and the Sherman Act, what the Sherman Act provides for and what are the restrictions under the Sherman Act on price fixing. And today we have enough the jurisprudence available under the Sherman Act, and we will discuss especially the price fixing by the cartels, and also we will also discuss about the effects of patent pools and price fixing and then how it is interacting with the Sherman Act. And price fixing is basically in different modes, and we in the beginning classes we were discussing about what is a cartel, and cartel is nothing but combination of two or more enterprises or two or more persons. They come together to the same table and fix the agreements, fix the terms and conditions, fix prices, and either to limit the production or supply or allocate the market, geographical allocation, sales quotas, and they engage in collusive bidding, bid rigging, and of one or more markets or even international markets. So, it need not be within the premises of one country, it can cross over to the other countries' borders as well. So, cartels are always considered to be pernicious, and it is considered to be not good for the market. And so, the competition law will always act upon cartels, and even we saw that the Sherman Act, Antitrust Act itself has formed to curtail or to limit or to control the trust which was formed to the formed those who were controlling the entire business in the United States. So, cartel is absolutely against the competition law. And price fixing, we can see how the price fixing is done, and one of the famous cases is in 1948 itself is the United States versus United States Gypsum Company. As we know that unlike in India, in United States gypsum is one of a building construction product, one of the most important building construction product in the US, which constitutes almost 90% of the building materials. So, it is very important this particular material for the construction of each and every building in the United States. And this gypsum is, everybody knows that it is a chemical which is extracted and which is used for the building. These buildings were controlled by this particular company, United States Gypsum Company, from the day one, and from time to time they developed different technologies. And the main allegation was that the United States Gypsum Company was controlling the market, as well as they are violating the Sherman Acts section 1 and 2, and the conspiring with its dealers, conspiring with other licensees, and then fixing. They have a patent and they are tying up with the patented product as well as the non patented products, the gypsum products. Thus, they controlled entire production, distribution, resale prices, and everything is fixed in the market. This was the allegation against the United States Gypsum Company, and they decide even the minimum prices for the patented gypsum boards to be sold by the distributors. Here you can see that there are two types of the gypsum boards mainly used by this, produced by this particular company, that is the closed end and the license open end, two boards. So, closed end is very superior in quality, cheap and non breakable, and the another one is the open end. So, in 1912 this particular company is a very old company. This company got a patent which is known as Huntsman patent. Huntsman patent is for the closed end board which form very cheap and also the superior in quality. So, it have a larger market in the United States, and this company was licensing to different people, and which they fix the prices for patented board, but the allegation was that through this particular Huntsman patent which is owned by this particular company, they try to regulate the prices of non patented boards as well. This was the allegation. So, here mainly the price fixing by the licensor, the gypsum company and the licensees, and through the license agreements. So, the main allegation was that the licensor and the licensees conspired together to eliminate the production of open end board and fix the prices of the patent board. To some extent we know that the intellectual property protection through the patent protection, you can protect the technology for a limited period of time, but at the same time the non patent products which you do not have any control over that particular product. If you tie up these patented product with the non patented product, it is tying itself. In the last class which we saw that tying is against the Sherman Act. So, through this price fixing, if the company is going to monopolize the market of two different boards which is patented as well as the non patented boards. So, it have a defensive, it have a pernicious effect on the market, and the consumers are going to be affected, and the prices are going to be fixed by these particular companies. And so, it is the price fixing is always considered to be evil consequences on the consumers, on the public, and cartels are specifically the cartels. The main objective of the cartel itself is to form is it's not only to control the market, but to increase the prices or fixing the prices, and cartels are considered to be always less productive and always they fix prices, very high prices, which is always considered to be the against the Sherman Act. Here in this particular case, so the price fixing, that means this particular company, gypsum company board, they produces boards with a patent, and through this particular intellectual property protection, through this particular patent, the company tried to control the entire market of this gypsum board, which is a very important material in the American market. Here the court found the evidence against this particular company. They are trying to control the particular market through this particular intellectual property protection. Here the distribution, again the plan, the complete conspiracy to protect the market is not within the purview of patent protection at all. The monopoly power through the intellectual property protection is only given for a limited period of time. For the theories which we saw, that the set theory, incentive theory. So, this is only for a small shorter period of time. So, the court very clearly said that the conspiracy to control the prices are against the Sherman Act, with referring to an earlier case in the United States versus General Electric Company. So, absolutely it is against the Sherman Act. So, again the industry wide license agreement, always the licensing agreements and the terms they cause, or they always play a very crucial role in controlling the particular market. So, because the licensees cannot never violate these license provisions, which the company can take action. So, through these licensing agreements, the conspiracy of controlling the prices and the methods of distribution which is prescribed by this particular company, it is established that there is a prima facie case of conspiracy to control this particular market. So, we know that the intellectual property protection is given only for a limited period only as an incentive. This is not to exploit the entire market. Whenever the exploitation of this intellectual property crossing the limits, then the competition law will come into play. Here the motive is absolutely different. So, the two theories which we will see later on, that is the prima facie evidences as well as the per se rule, we will see later. And here it is for the company to take the defense or to justify their action, then the per se, the per se rule as well as the other rule can be applicable, and but no intellectual property owner can exploit the market beyond the limits of intellectual property protection. So, the gypsum company cannot control the non patented gypsum boards market through the patent which they are on. So, the court very clearly held that the company violated the provisions of the Sherman Act. And again, if you look into this particular case, this many principles were emerged, that is a group of competitors enters into a series of separate but similar agreements with the competitors. So, definitely there is a smell of the competitors comes to the same table, it means there is a smell of cartels. Cartels are against the competition provisions. So, there is an inference of cartelization or a concerted action to control the market or fix the prices. Then again the provision in the patent licensing agreement on payment of royalties and other things, for payment of royalties for the patented board as well as the non patented board, which is again an indicative of agreement not to manufacture that particular board, not to manufacture the non patented board as well. So, that means a company who owns an intellectual property, they try to extend the protection of their intellectual property to a non patented product as well through a licensing agreement, absolutely against the competition provisions, against the Sherman Act. So, the purpose is very clear, to increase the competition in the market is the purpose of competition law, but these kind of activities are absolutely preventing this. Then again the rule of reason. The rule of reason principle very clearly says that applicable to efforts monopolized through patents. So, the rule of reason is one principle where this we can analyze whether the action of this particular company is violating the competition law or not. So, if the company is found to be violating, abusing the market power, then definitely it is come within the purview of the prohibitions under the Sherman Act. This is the first case, and when we come to the other case of this another case, famous case in 1998. So, I have selected some old cases, some new cases, so that we can understand the attitude of the courts, how they taken different stands. So, Adamax Corporation versus Open Software Foundation in 1998 case. Here also this one company is making the security software for Unix operating systems. Here you can say that Unix at that particular point of time monopolized the working with Sun Microsystems, another company. So, some other companies, 2-3 companies come together and they formed open software foundation, they formed, and the main companies, those the sponsors of this open software foundation as HP, that is the Hewlett Packard company, which is still there, and they are the sponsors of this open foundation. So, here you can say this particular company which was making the Adamax, which was making the B1 security software, and they were phasing out this particular software B1 security software in 1991, and this 1991 itself, and they were developing a higher version of the security software in 1991. At the same year, they filed a case against this open source foundation, because they found that this open source foundation is parallelly making this software, security software, which is going to be a threat in the future. So, as I told you, this was the open source foundation of open software foundation, which was founded by the Hewlett Packard and Digital Equipment Corporation in 1988 itself to form these security softwares. And they filed the claim that there is a price fixing, there is a horizontal price fixing, boycott. So, the allegation was that there is horizontal price fixing, boycott, unlawful joint venture, and joint venture, whether the joint venture itself have the behavior of cartelization This is one question, and another question. So, can you form a joint venture company is per se is illegal? Absolutely not. Any companies, any companies or any people can come together and form joint venture is absolutely within the purview of law, and to form new products and new processes and new innovations. So, but it is alleged that this particular open source foundation and these companies come together and form this particular company as a cartel to fix the prices. And also you can we know that in the market, boycotting a company, boycotts and concerted refusal to deal is also violation of Sherman Act. Then again the flinging around terms like cartel, boycott do not convert a rule of reason claim into a per se one. This is the court finding. So, that means boycott itself or converting the rule of reason claim per se is a foundation, forming a foundation or a joint venture per se is not violation of competition law. So, the joint venture also per se is not illegal, it is legal. So, but the doubt, the cloud of doubt will come only when the activities to be analyzed. So, the rule of reason, so the conducted, so if we condemn such foundations only when this foundation is going ahead with any anti-competitive effects. We will see this particular case what are the other activities. So, the main allegation by this company is that the joint this new open source software foundation is a joint venture is their activities are anti-competitive in effect. And then see, remember, so we were talking in the whole every time we were talking about these companies, those who are selling and their anti-competitive practices, and here the first time the question arises purchasing. The purchases come together and they form a cartel in order to fix the prices or in order the bargaining power, in order to bargain the prices. So, here the consortium have a monopoly purchase power. This was another allegation in this particular case. And again they said that the defendants are conspired to force down the price for security software below the free market level because of their purchasing power. Then the question is, you have to analyze the balance of harms and benefit. What is the harm and what is the purchasing power? So, balance of harms and benefit, if it is beneficial to the society, we saw in the earlier cases that the main objective of the competition law is the welfare of the market, welfare of the consumers. So, you have to analyze whether the defendants, the purchases come together, whether it is good for the consumers, good for the society, good for the market, or whether it have a effect on the particular market. Concentration of purchasing power is also one of the important factor which is raised in this particular case. But unfortunately, in this particular case the plaintiffs, this Adamax has not succeeded in this particular case, because the conduct of the defendants to come together for some kind of research, the court found that you cannot allege somebody is forming a joint venture itself per se is not illegal. So, you have to prove the illegality or anti-competitive practices, and here the court found that the naked price fixing cartels run by sellers of goods or devices are per se illegal. So, if anybody is formed cartels for price fixing and selling goods, that is per se illegal. Then again buyers cartel, not only sellers cartel, the court held that the buyers cartels are also per se illegal. Then again technically, if looking into this particular case, the anti-competitive impact or rule of reason, applying the rule of reason, whether it is good for analyzing the beneficial effects on the society. So, the court found that here the plaintiff, because of the activities of the defendant, the open source software foundation, the plaintiff have suffered no damage. So, the antitrust lawsuit cannot be filed, because there is no damage to the plaintiff at all. Then again the plaintiff was failed to prove that the alleged injuries to this particular company, because the company were not doing very well. You cannot, if your company is not doing very well, you cannot allege that particular allegation to the other company that the other company is using their abusing the market power, or that your failure cannot be attributable to your defendant. So, you are absolutely or conduct of the defendant, and you are absolutely failed in that particular terms. Then price fixing cartels. Price fixing cartels are always held to be illegal, and bias cartels are also held to be illegal. And unfortunately, in this particular case, it is the Adamax has actually wants to prevent the open source foundation to stop their research activities, which is have a impact, which have a future impact on Adamax, which was failed because of the court findings, and the court ruled against Adamax. So, it is very clear that the rule is very clear. Somebody is doing your competitor is doing your business, you cannot stop them by filing antitrust cases. You have to prove the antitrust violations, section 1 and 2 of the Sherman Act, then only there must be restraint of trade, and they are abusing the market power, they are fixing the prices or the tying arrangement. So, there is no circumstances under which this was proved by Adamax, and the case was rejected by this particular court. And next we will see the another concept, which is known as the patent pooling. That is, many patent owners come together with their own patents and pool their patents in order to maybe capture the market, the smooth functioning of the product. So, the question is whether the patent pooling itself is for price fixing, or patent pooling itself is per se illegal, or patent pooling is good for the society, patent pooling is good for making good for innovation. This we are going to discuss. So, we will discuss in between licensing, cross licensing, whether they have anti competitive effects or competitive effects on the market. So, integrating complementary technologies. So, many people comes together to the complementary technologies, they come with their complementary technologies, and they come with their product, their innovation, and they pool it together and to form a particular product, and they get the royalties. They divide the royalties, whether it is good for the consumers or not. That is integrating complementary and supplementary technologies. The economist very clearly says that this reduces the transaction cost, and there is this clearing blocking positions or blocking patents, and avoiding costly infringement litigation between the companies, and it is pro competitive in nature. The economist very clearly says, and we will see some of them. So, collective price, whether this is restraint of trade, whether it is anti competitive in nature, then output restraints, joint marketing of pooled IP with price setting, all this I would say that pooling is nothing but it is whether it is have the any contact of cartelization, then the scenario will be different, because many people comes together and pool their technologies and supplementary technologies or complementary technologies, and they come out with the product and they fix prices. But this is per se anti competitive, the answer is no. So, here again we have to look into the transactions, whether there is a collective pricing, whether there is any output restraints, whether there is a joint marketing of pooled IPs by setting the prices. So, here in the Singer manufacturing company versus United States, it is very clearly said cross licensing agreement was part of broader combination to exclude competitors. So, cross licensing may not be always anti competitive in nature. The cross licensing may be good for both the companies in order to avoid litigation in the modern times. So, exclusion. So, suppose again the question, if there are 5 people comes together and they exclude 2 other people collectively, exclusion from pooling, exclusion from cross licensing, then again we have to look into the market power of the people, those who come together, whether they can harm competition. If these people, those who come together, can harm competition in the market, then this pooling it can violate, or attract the provisions of competition law. So, the pooling to be all non-discriminatory, and who would like to join? Anybody wants to join, let them come and join in the pool. It is non-discriminatory. So, then it is not going to violate any of the competition provisions. So, exclusion clause, the exclusion of competitor from purchasing the cooperative, because cooperation, pooling is nothing but cooperation of competitors. They come together and they become the market power. So, if you can show that there is the market power is absolutely controlled by this exclusion of pooling of these particular innovators, the pooling of intellectual property, and but you have to prove it is unlawful and violating the competition law provisions, that is the or antitrust provisions. And here again, if you can prove that there are pro competitive effects, it is helping the economies and integrating supplementary and complementary technologies, and the pool members are benefited as well as if the society is benefited out of the patent pooling, then there is no violation of the competition provisions, that is the Sherman Act. But if you look at the conditions which you can say that, so if the excluded firms cannot effectively compete in the relevant market for good incorporating the licensed technologies, and also the pooling when the participants collectively possess the market power in the relevant market, then the case will be different. Then efficient development and exploitation of pool technologies is one of the justification. Then if any kind of pooling retarding innovation, then it is definitely going to affect the market, then also it is going to be violative of the Sherman Act. So, then another is excess royalties. So, here the patent owners, the combination of patents which we talked about pooling of patents, if they dominate the particular market, the quantity is fixed, if the price is fixed, the marketing terms are fixed, the condition terms are fixed, the territory, they divide the territory, then thus all the conditions constitute the controlling is to control the particular market, then definitely there is a inference or evidence of eliminating competition from the market and to fix higher prices, which will be definitely considered as unlawful combination. Then definitely it will be violating the provisions of the Sherman Act, and this was held in 1931 itself by in the Standard Oil Company case versus United States. So, if you look into all these parameters, you have to prove that the patent pooling is violating, it is pernicious or it is against the market, the symptoms are very clear. So, then you can prove it can be considered as violation of Sherman Act 1 section 1 and section 2. Then again contracts, the contracts, as I told you, the license agreement and contracts play a very crucial role in patent pooling. It may be for controlling the Indian industry itself. So, the royalty rates always control the prices. If the royalty rates are very high, then the prices are going to be very high. So, patent pools, it is considered that sometimes with the patent pools, because the many writers like Roger B. Anwalt and others, they argue that this may have a positive effect, the patent pool have a positive effect on the consumers and a negative effect on the consumers, because it will depend upon the objective. What is the objective of this particular people come together? What is the objective of these patent pools? They are originally they are reducing the competition in the market, or it is pro competitive in effect, that we have to analyze. Here pooling and cross licensing. So, we can always say that cross licensings are mostly pro competitive in nature, until you have to prove certain conditions, because the companies, those who are cross licensing, can use IP effectively and avoid litigation, because there is a huge cost involved in litigation cost. So, if you can reduce the litigation cost, you can very well reduce the litigation cost through the cross licensing. So, collective pricing, see again there is a possibility of collusion in the collective pricing, the pricing may not be fair in the market, there may be a higher prices. So, if you have you have to very closely look into the collusion, what is the objective of the collusion, and pooling is nothing but collusion, but all collusions are not against the all collusions are not anti-competitive in nature. So, if there is a larger number of market participants and there is a pro-competitive effect in the market, then definitely this pooling have a welfare effect on the market. And bundling always says the bundling reduces, bundling of patents or pooling of patents reduces transaction cost. Transaction cost, this is actually held in the US Microsoft case, but Microsoft lost this particular case, but the court held that bundling must be for reducing the transaction cost, it should not increase the transaction cost. So, that is why I said in Microsoft case, tying is an unwanted product tied with another product is against the competition law. And the pooling benefits, the consumers may benefit from combining different technologies, that is the objective of pooling. The consumers must get the benefit out of the particular pooling. And joint sale of complements, the joint sale of complements will reduce the price than the independent sale. So, if 10 people comes together and you sell it, the prices are going to reduce rather than independent sale, there is a possibility of increasing the particular price. So, the blocking patents, so always you have to look into what exactly is happening in a case by case basis. So, if you can prove that there is a pro-competitive effect, it is not going to be against any competition law, no the Sherman Act provisions will attract it. So, here the patent pooling benefits, the patent pooling benefits are, or if it is passing to the society, then definitely it is pro-competitive in effect. So, in this class we saw that the patent pooling may have a pro-competitive effect, as well as if you can prove there is a pro-competitive effect, then it is not violating any competition law provisions, it is not violating any the Sherman Act, any of the provisions of the Sherman Act. But if there is no pro-competitive effect only for making cartelization and fixing prices, then the Sherman Act, it will attract the provisions of the Sherman Act. So, the interaction between intellectual property and competition law, the borderline is very thin. So, you have to prove the anti-competitive effects on the market, whatever you do, whether it is pooling or the cartels, because the cartelization per se, is not illegal. You have to prove the ingredients of cartelization for increasing the prices or fixing the prices or limiting the market or limiting the sales, you have to prove. So, it is clear that, so intellectual property is providing you a protection for a limited period of time. So, monopoly is given to you only for a limited period of time, and you exceed that particular limit, then the competition law is going to be come into play. Then competition law will visit you with the provisions of the Sherman Act section 1 and 2. So, you can very well act within, you can make you can pool your technologies together if your objective is good, if it is good to the market, if it is good to the consumers and good to the society, then the competition law is not going to visit you, otherwise the anti-competitive effects will be proved and the Sherman Act is going to be in place and you are going to be fined accordingly. Thank you.